Hello friends, how are you? Good morning to all of you. Today I am going to share this video in respect of section 145 of Negotiable Instrument Act. Section 145 says that evidence on affidavit. Section 145 is inserted in the year 2003 in Negotiable Instrument Act. The scope of the applicability of section 145 is: this section is applicable only for the offences committed under section 138 of the N.I.ACT and not for any other offence committed under IPC. This is the scope of section 145 of N.I.ACT. Now, this section is divided into two parts, 145.1, 145.2. So, let me discuss 145.1. The ingredients of section 145.1 are like this. This section, by way of this section, the complainant himself gives an evidence on affidavit. This is the first ingredient. Second, section 145 subclause 1 begins with non-obstantive clause. Now, what is that non-obstantive clause? What does it mean then? It begins with notwithstanding anything contained in CRPC. The meaning of this clause is whatever may be contained in CRPC, in spite of that contention made in CRPC, this section is applicable. Or the meaning of non-obstantive clause further is whenever there is conflict between this provision and the provisions of CRPC, then the provision of 145 is prevailing over that. This is the meaning of non-obstantive clause, and that is why this section begins with notwithstanding anything contained in CRPC. Because there are other provisions in CRPC like section 251, section 251, 254, 274 of CRPC are available prior to the section of 145 to conduct the case related to section 138 of N.I.ACT. That is why this non-obstantive clause is required to be inserted in this provision. Now, another ingredient: such affidavit made by the complainant may be read in evidence in any inquiry, trial or other proceedings under CRPC, subject to all just exceptions. These are the ingredients of section 145.1 of CRPC. Now, what about section 145.2? The ingredients of section 145.2 are: 1. The court may, if it thinks fit. 1. I have divided this section 145.2 in 3 parts: A, B and C. I have just said about A, the court may, if it thinks fit. Second, that is B, and shall on the application of the prosecution or accused. This is B. And third, that is C, summon and examine any person giving evidence on affidavit as to the fact contained therein. Now let me discuss the ingredients in this regard. A, that is, the court may if it thinks fit. This clause establishes the discretionary power of the court to proceed further. Now clause B, and shall on the application of prosecution or accused, meaning thereby this clause suggests that an application can be made either by the complainant or by the accused, and thereafter the court shall proceed. C, summon and examine any person giving evidence on affidavit as to the facts contained therein. This clause says that any person can give evidence on affidavit. That person who gives evidence is summoned and examined by the court. Now, interpretation of this clause is like this. The court issues summon and examine the person. Here any person does not mean the complainant. Any person means other than the complainant. To give evidence on affidavit in respect of the facts mentioned in that affidavit. This is the interpretation of section 145. Friends, I hope you like this video. Please share this video. Please, I request you so that and subscribe the channel as well if you are really interested in having such type of videos which are really knowledgeable in respect of various laws. Thank you very much.